Good morning. Please be seated. We're here for oral argument in 1CA CV19 0019 Netherlands versus MD Helicopters. These proceedings are being audio and video recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes, or apparently 19 minutes and 59 seconds. And appellant's counsel, you're responsible for watching the clock to reserve any time or any portion of your time for a rebuttal. We've read the briefs. We've discussed this matter at conference this morning. Counsel, you may proceed.
And before you get started, we've got 1 second short. There we go.
For both.
For both. I couldn't see the other one behind the water. Excellent.
Good morning. May it please the court, Doug Janisic on behalf of Appellant MD Helicopters. I'll try to reserve 3 minutes for rebuttal. Recognition of foreign country judgments is a matter of state law. And in Arizona, our legislature has spoken definitively on the issue. It adopted, in part, the Uniform Act for recognition of foreign country money judgments. But pertinent here, the Arizona Act deviates from the Uniform Act in two material respects, both of which are dispositive here. First, the Arizona Act included a strict reciprocity clause that the Netherlands has not and cannot satisfy. Second, the Arizona Act omits a savings clause that would otherwise permit recognition of a foreign country money judgment under the common law if the judgment creditor could not satisfy the Arizona Act. Under settled principles of statutory interpretation, this court must presume that omission was intentional. Thus, the Netherlands cannot resort to the common law, and this court should reverse the Superior Court's order recognizing the Hague judgment. Let me begin with reciprocity. The plain text of the statute governs here. A foreign country must have enacted or adopted a reciprocal law, singular, that is similar to this chapter, referring to the Arizona Act. It didn't say common law. It didn't say case law. It also didn't say that a foreign country a foreign court could adopt requirements or factors that are similar to those that are in the Act.
So what do we do with the Dutch case law that's been in place for over 100 years that is similar to the Act? Ignore it?
Well, we would disagree that it is similar to the Act,
Okay.
Your Honor. There are at least three key differences.
Okay, why don't you get to those three key differences in your opinion?
Number one, personal jurisdiction. Under the Arizona Act, personal jurisdiction, once established by the foreign court, is set. That is all that is required. In the Netherlands, the court considers whether the assertion of personal jurisdiction is, quote, in accordance with international criteria, a term largely left undefined. Those words aren't in the Arizona Act. More importantly, the Netherlands courts, and this is in fact in the cases that the Netherlands submitted in their appendix on this appeal for the first time, the Netherlands courts referred to the legal reasoning of a foreign judgment. If you look at the Netherlands appendix, page 13, this is a Dutch case recognizing a foreign judgment. It says, the Rotterdam District Court is of the opinion that the judgment satisfies the requirements of sound reasoning. Another one, Netherlands Appendix 24, quote, there is no question here of a violation of a rule of law that is considered essential in the Netherlands. There is no such language in the Arizona Act. Under the Arizona Act, we don't look at the underlying legal reasoning, whether it was sound.
Oh, I thought you argued at length about public policy and those kinds of things. Isn't that part of the whole looking at whether or not the criteria is the same?
I disagree, Your Honor. I think public policy is much broader principle. In the Netherlands courts, they consider whether it's in conflict with Dutch public order. Under the Act, the language is actually repugnant to Arizona public policy. But be that as it may, this legal reasoning of a decision is far different than the public policy of a state. The Netherlands decisions are, and this is the problem with the relying on case law, which is why the legislature wanted that strict reciprocity clause to refer to a statute, a treaty, something from a lawmaking body.
And go ahead.
Which do you have a case, a Dutch case, where you think they have improperly declined to enforce a judgment based on reasoning? If the court is just saying this decision is based on sound legal reasoning and enforces a judgment, is there something where they've taken issue and said, look, these United States courts don't apply principles that are necessary for us to honor such a judgment?
Absolutely, Your Honor. In our supplemental appendix, we put two decisions. One is a California state court judgment awarding $1 million in punitive damages. Another was a Tennessee state court judgment awarding $250,000 in punitives. And I will note that the Tennessee case is a 1-to-1 ratio. The compensatory damages in that case were $250,000.
So it's a refusal to enforce the punitive damages?
Correct. And here's what the Dutch court said, and this is again at our supplemental appendix, page 39, with respect to the California judgment. The damages, quote, are extremely high in Dutch terms. That has nothing to do with public policy. That is simply looking at the amount awarded and saying that's too high. That is second guessing. That is revisiting the merits of a final U.S. judgment. The Tennessee case, the 1-to-1 ratio, here's what the court said. It said, quote, the damages, quote, relate to punishment for improper behavior, a concept that does not exist in Dutch law. So they are essentially saying we don't follow U.S. law on punitive damages. And again, our big point here is these are examples of cases where the judgment from the U.S. is not enforced. That is the problem. It's inherently unpredictable. That's exactly what our Arizona legislature...
Any examples other than punitive damages?
We cited in our papers, in the opening brief, a series of cases, including the Third Circuit case. So there are cases where the courts have recognized that it is very unpredictable what's going to happen in a Dutch court. And if I may quote from the Third Circuit, this is 830 F2D 1260, Third Circuit 1987 case cited in our papers. The court noted that a Dutch court, quote, is free to attach significance to a foreign judgment as it sees fit. I don't know how much more that can be unfettered discretion, which is precisely what our legislature said no to when it put in a reciprocity clause and said a reciprocal law. They wanted certainty. They wanted some form of assurance that there would be comity between the nations, a relationship with the country.
Well, except it says a reciprocal law that will be similar to Arizona. It doesn't have to be identical. It just has to be similar to our law.
That is true, Your Honor, except why did they say a foreign country must adopt or enact a reciprocal law? Under 3251, the definition of a foreign country is a government, not the government's courts. We know that because in that same section...
So are you saying that the courts aren't part of the government? I thought we were the third branch.
In the United States, that is true, Your Honor.
So does your reasoning in the United States, let's say you're trying to get something recognized and you're from the Netherlands, could our precedent not suffice as the reciprocal?
Well, our legislature has said they want a law. So in Arizona, they are looking for that reciprocal arrangement.
Why would we read it that way? Because in the United States, law can be common law, it can be administrative law, it can be statutory law. The legislature could have defined it more specific, and they didn't. They said a law, recognizing that there are many countries out there and many ways to adopt law. But they didn't define it specifically to a particular type of law.
That is true, Your Honor, but why then say a law similar to this chapter and not say, requirements that are similar to this chapter? The singular is very important here.
But it is the law it's the law in the United States if it's a determination by a court, whether it's a statute. This is the law in the United States. Is that just a?
But we're talking about foreign law. We're talking about a reciprocal law from the foreign country.
If a court in a foreign country specifically says this is the law in our country, and there's no statute that says that, we wouldn't honor that?
That is exactly what the legislature said. If you remember in the legislative hearings, the very impetus of this legislation was the Alberta Canada Act, RSA 2000, Chapter R6, cited in our papers. That was specifically referenced in the hearing as the impetus for why we want this act passed, because we know they have an act passed on their side. So the whole context of the passage of this bill points to that reciprocal relationship.
It's not necessarily that they've passed it through legislation. We just know that this is how we will be treated in that country. And couldn't we say the same thing if there are legal decisions from a court in that country?
But the importance for the legislature here was that was on the books. It does give the certainty. The problem with the common law, and first of all, many countries are civil law countries. They don't even know what common law is. So the problem with common law is it's ever changing. It's modified, it's overruled, distinguished. What they wanted, and that's specifically in the language they chose, is a reciprocal law, something we can point to.
And 100 years of precedent in the Netherlands is not adequate to fulfill that.
According to our legislature, no.
We could pass a law, there could be a statute that would be unconstitutional. That wouldn't help another country if you don't consider it in the context of laws are also reviewed by courts. It seems hard to just kind of divorce everything from and say it simply has to be a statutory enactment.
Well, Your Honor, I would point to the fact of exactly what the language the legislature chose, but I do want to argue that even if you accept the premise that case law is enough, how did they meet their burden in this case? In a response to a motion to dismiss, they referenced 2 Dutch cases. The cases aren't actually in the record below. The commissioner didn't take on, as far as the record shows, any obligation or effort.
We review this de novo, and because it's a matter of law. So we can look at the cases that were presented below. We can look at cases that are cited that we find on our own. We're not limited. If they had only presented one case, we're not bound by that case, even if that case had been overruled by another court.
That is true, though, Your Honor. Rule 44.1 does require the party to aid the court in its decision. So they come forward with several other decisions in their appendix, but then we come back with 2 that go the other way, which is precisely our point. There's absolutely no predictability. Even the factors themselves, they're not the same. They talk about once all the factors which are not the same as what is laid out in the statute, even if those were all met, the Dutch court says the judgment will be, quote, allowable in principle.
Can I stop you right there?
Absolutely, Your Honor.
Okay. We'll get to your penalty argument here in a moment, but if we assume punitive damages are in fact penalties under the definition of this act, what other context does the Dutch court case law disavow a U.S. judgment in your review of Did that make sense? You're giving me a look like it didn't
No,
make
it
sense.
does, Your Honor.
Okay.
I would say wherever it questions the legal reasoning. There are cases, there was a bankruptcy case we cited where the court said it's very likely that a bankruptcy judgment won't be recognized in the Netherlands. The problem
But
with...
it didn't definitively decide.
It didn't, but the problem is the discretion left to the Dutch courts with this, quote, allowable in principle is in stark contrast to the statute, which says under 1232(53), if otherwise the statute is met, the trial court shall recognize the foreign judgment. That is vastly different than how it's handled in the Netherlands.
But the act also includes discretion on the part of the trial court about whether or not to recognize the judgment, does it not?
It does, but they are enumerated and they are very specific as to what can be considered. Legal reasoning is not one of them. In fact, on personal jurisdiction, where the Dutch court will actually look at international criteria, our statute says in 1253, E, lists out things, certain conditions that, if met, you cannot say there was no personal jurisdiction. It actually restricts the trial courts here in Arizona discretion to say, well, I don't think this personal jurisdiction really holds up. In the Dutch courts, that is a question of international criteria. So whether or
Which
not...
may or may not include exactly what you're talking about. I mean, this doesn't go back to my question earlier about it's not identical. It just has to be similar to. Because if we don't have to put a moniker on it and have it exactly the same, it just has to be similar to.
That is true, Your Honor. And again, I would go back to it. I get the argument it has to be a legislative act. But beyond that, if the court does get to the issue of whether case law is enough, I don't think that burden is met here. It's a series of Dutch court decisions that consider certain factors, could go either way. It's essentially leaving comedy up to a judge's discretion over in a foreign country. That is not what our legislature, that's not the language our legislature used. Yes, Your Honor.
When you look at the principles we're discussing and you look at the fact that this necessarily involves the United States dealing with foreign countries that have different forms of government and different regulations and different. When they included the similarity language, were they not including that to give a certain amount of flexibility to the other countries so that we have reciprocity? I mean, the whole point of this is so that an American could go somewhere else and enforce a judgment, and that someone else can come here and enforce a judgment. So if we have to adhere so strictly to what you're saying, or what you're positing, is that it has to be a legislative act, it has to track our language specifically, there can be no discretion on the part of the judge, those things, would it not apply to any other country?
Well, let me start again by the premise that what the legislature, yes, they were trying to do that, but specifically in the context of an Alberta law, they looked to and said, yes, that's reciprocity. But more importantly, I'm not saying there can be no discretion. I'm saying the discretion afforded under the statute is confined to very certain conditions. In the Netherlands, in our briefs, we laid out the broad language that appears in decisions. And these are decisions they submitted where you have words of legal reasoning. Is it in accordance with our law? Those aren't factors at all anywhere in the Arizona Act. I see I only have 2 minutes left. I'd like to reserve those for later.
All right, thank you, counsel. You may proceed.
Thank you, Your Honors. Judges Campbell, McMurdy, and Catani. May it please the court. My name is Brad Weech, and with me is Marshall Hunt. We have the pleasure of representing the state of the Netherlands here in this case in front of you here in the state of Arizona. With us here today, I would like to acknowledge the Dutch consul is here, and from the state of Netherlands who have traveled here for this proceeding is also the government representative and local Netherlands council. Now, having said that, I would like to take us quickly to a point that I think will help and clarify a couple of points. One is the state of the Netherlands happens to be the country that was singled out by the United States Supreme Court in the Hilton versus sorry, I paused, Guyot. I could never remember exactly, and I'm sure I'm not pronouncing that name right, but in that 60-page decision, this country was singled out as being the, if not the, one of the most fair and just judicial systems in the world, and they have maintained that throughout. Now, what I want to take you to now that's particularly relevant to this case is page 32 of the reply brief, because on page 32 of that reply brief, we find discussion of what was the Bonne-Montel case, but in particular, a specific reference to the Gazprom case. These are the two cases that we presented to the trial court, and we have presented them to you. Now, in the reply on page 32, at section 4.3, we have a clear explanation for us here in the United States as to how the Netherlands developed their domestication of foreign country law. And this is how it goes. And I'm going to give you a date that goes back way beyond what we've even thought. In 1839, this civil law country passed a code in the Dutch Code of Civil Procedure, Code 431, giving their judicial branch the authority to develop the domestication of foreign judgments and under what criteria those would be. And so if we look at this case presented to you by MD, and I'm going to refer to the appellants as MD for short, and I'm going to refer to the Foreign Country Money Judgments Recognition Act, which is a mouthful, to the act throughout my discussion here. And I want to read this into the record because this makes it exactly clear what they did. And it's not entirely different than what we do here. And I'll explain that as well with our statutes. Because it says, first of all, there is no treaty in force between the Netherlands and the United States of America with respect to the recognition of judgments. Now the important part. This means that the question of whether the judgment has authority must be answered by applying Article 431 DCCP on the grounds of the criteria developed for that purpose by the Dutch Supreme Court. And then the reference there to the Dutch Supreme Court, September 26, 2014, is the Gazprom case. And the Gazprom case is the one that discussed further the Bonne-Montel case, which I believe was many years before that, where the Dutch had developed their domestication of foreign judgments law that has continued without substantial difference to ours since that point in time.
Counsel, I am going to interrupt your thought process here. You don't disagree that there are certain type of American judgments that the Dutch court doesn't recognize, right?
That's correct.
Punitive damages,
Punitive damages?
some bankruptcy judgments.
There are some bankruptcy judgments, yes.
If there is a type of judgment that is not recognized by the Netherlands, does that mean that all judgments are not to be recognized? All American judgments are not to be recognized?
No.
Or, under the Act. I said that incorrectly. That if the Dutch court does not recognize those types, then we're not going to recognize.
I understand
any
the
of theirs.
complexity of
All
the
right.
question and how complex it is to try to phrase it. I think you're asking, does our Act then say that these and only these foreign judgments that qualify here are the only foreign judgments that can and will be recognized in this state? If they are included, yes, they are. If they're excluded by the exclusion provisions, then they're not. And the argument made by MD is so extreme as to say just exactly what you said, and that is that if it doesn't come within the Act, the state of Arizona no longer recognizes those other foreign country judgments. It will put us, as the state of Arizona, in a singular position of being the only state in this union that does not continue with the tens of decades, 100 years or more of comedy in this great United States of ours. We will be the only state if you rule for MD in this case, we will be the only state, and we will have singled ourselves out as being unfriendly in a way that is so dramatically and extremely different from what we have been and what the legislature even has participated in and what this court system under the common law has participated in. I want to take you back to what I quoted from that case. What they did is they do have a legislative act, an argument made by MD Anderson that the act says it's got to be a code. It's got to be something from a legislative body. Forget the other branches of government that we have. Forget the other branches of government that the Netherlands has. It has to be legislation. Now I'm going to remind, as we've pointed out in our briefs, that when this state became a state, I'm sorry, I'm a native from this state. At that point in time, we enacted ARS 1-201, which codified the common law. Our legislature codified the common law. In ARS 12-122, this court and all other courts in the state were given direction to apply the common law. Now, MD would argue to you that with one swipe of a pen in a 4-section statute that clearly was designed to streamline the process, create a fast track, a fast lane for the most simple of all judgments, money judgments from foreign countries, that by doing that they undid 12-122 and 1-201 as it applies to the recognition of foreign judgments.
Well, they could have. I mean, the legislature could have said we're abolishing the common law as it relates to the recognition of foreign judgments, couldn't they?
They could have said that. I would anticipate that there would be a great deal of litigation over that since we, as a country, adopted the common law. And that's not an issue for today, but my response to that is yes, they could. The legislature, when it's in session, I think the common phrase is it's very dangerous. Don't be surprised at what may come out. We are all in great jeopardy when the legislature is in session. I don't mean that in any sort of negative fashion, but we all know those comments because the legislature can do, and then some of what they do is challenged.
I'd like you to address some specific wording that MD brought up. Legal reasoning in the Dutch context. How does legal reasoning play into recognition of a foreign country's judgment? We can't do that under this act coming the other way. Would you agree with that? Get into the nuts and bolts?
No, I would not.
Okay, then tell me about
Because this act, as I said, has inclusion provisions and it has exclusion provisions. And some of those exclusion provisions that are being argued by MD Anderson, for example, is repugnancy. We're really here on 3 issues: reciprocity, penalty, and repugnancy. Those are the arguments that are actually being argued here. The argument to go to this legal reasoning and personal jurisdiction have no practical impact on this particular case. They're only being used by MD Anderson to try to distinguish and say that the Netherlands judicial system and their recognition of foreign judgments is so drastically different than ours that it is not similar. That's the only reason that's in here. But in the repugnancy, and if you'll apologize. And I see that I still have plenty of time to take a drink. When you get into the definition or the repugnancy issue, discretion is particularly given to the trial court. And so as to repugnancy, legal reasoning, if you want to start to compare the concept of, is it different? Do they have too much? Are we going to exclude Dutch judgments because their court system allows the judicial system more freedom in certain areas, here, or here, but not here, or here, and maybe we take a more strict view in regard to some of the different types of cases that we have? The legal reasoning is not any different than some of the applications that we apply here at the trial level and at this level on a de novo review of some of these issues. Here you are sitting in de novo review of the statutory interpretation, in whether summary judgment should be granted, but you are on abuse of discretion basis for your standard of review as far as repugnancy goes for both the act and for the common law.
Could an Arizona court, for example, consider whether a foreign court applied principles of due process that didn't allow a party to respond? Would that be something that?
Absolutely. And I believe it's specifically spelled out in the act and would be a part of our standards for whether to recognize
so
comedy.
that could be, in theory, part of the court's decision was well reasoned. There was a basis. The parties were given a full and adequate opportunity to present their issues.
Absolutely. Absolutely. I agree with that, and I don't know that anyone could reasonably disagree with that. They are given discretion on, even as much as a legislature might want to write down, you must have X, Y, and Z. Yes, there are occasions when it's very clear as to whether X exists or not. As to Y and Z, it may not be quite so clear, but that's where it's put to the court to decide those things. But it doesn't mean it's an automatic exclusion. It doesn't mean that the common law was abrogated. It doesn't mean that it is missing from the inclusion requirements of the Act, or that it satisfies the exclusion requirements of some particular piece of the Act. And this is a uniform Act, has been created in 1962, not modified until about 45 years later, and modified to actually address some of the issues that some of the courts were going in different directions on. It was adopted by 32 states in its original state. It is now, in its original creation, it has now been adopted by, it was 23 at the time of Judge Rogers' decision, and it is now at 25, with a couple of pending right now. And I cannot say enough for a...
But there aren't many that have a reciprocity provision of their when they adopted the act, correct?
I don't know the answer to that because we haven't looked to see that. But as far as reciprocity goes, it won't matter in this case because we do have reciprocal law. And we've even, as I said at the very beginning, identified for you where it is not only court-created law, but it is designated by the civil law of the state of the Netherlands to delegate to that judiciary to create the specifics, and they did. In all three of those cases, including the one that I cited to you under 4.3, what I did not continue to read were the specific requirements that they specify there, as well as in the Gazprom case and in the Bon Montel case. And when you set those, take the three from the Netherlands and take the act or take comedy in this state and set them side by side, undeniably they are similar. Undeniably there are either some differences or possible differences. But on all the major points, they are similar. And that's what this statute requires. In fact, the uniform portion of it requires that it be similar, not identical. You don't have to, as Judge McMurdy, you stated, you don't have to hang the moniker on my coat to make it the same as Mr. Hunt's coat. We can have different colors of coats, but they're still coats. And we don't have to have a moniker hanging on there to make sure we are identical. What we do under this act is what we have always done. What we have always done under the application of comedy. The principles, in fact, those three that I labeled off, are all part of both tracks, whether it's through comedy or whether it's through this fast track system for those simplest of all cases that can move through that track, that are included and not excluded. Then they come out the other end more quickly, and these again are money judgments that help commerce and investments going both directions, which we know is the impetus for the act.
If that's the impetus for the act, and why was the act needed? What kinds of issues was it meant to address if common law was taking care of it just fine?
Why was it needed? It wasn't that there wasn't a process in place. It was that there was not a simpler process in place.
Well, if you read the legislative history, it appears that the Alberta court, or the Alberta province, or whatever we want to refer as, was not accepting our judgments.
No, it wasn't that they weren't accepting the judgments. It was that it was more difficult because you had to start all over afresh from the beginning with a new lawsuit there. Not unlike our system here, where you can actually, one of the methods that still exists is to file a judgment here in a regular case. Even under the Sister State Act, you can still file the judgment from the other state here and pursue it as through the normal course. That was the only course that was available. So there was a track there to do that. It just wasn't as simple and as direct. And so what they had was a situation, again, if you go back to the legislative history, it talks about that, but it talks about the fact that the adjusters, the loan processors, the loan approval process in the banks here took that as a negative. Now, every statute that's passed almost always has one particular issue that they're dealing with, but yet the statute comes out the other end and it has broader applications. So this one, obviously by the wording, doesn't reference Alberta, Canada. It doesn't reference the Bankers Association, and it doesn't reference a lot of other specifics that we could be put behind why this act started. But the point was that the investors would like to use their property in Canada as collateral for loans in the state of Arizona so that they could invest their money here, and yet the banks were a little bit hesitant about doing that because if that fell through and they needed to sue that borrower, they didn't have a good process up in Canada to do that quickly. So this was a fast track that made sense, as I said before, for the most simplest of judgments, those being money judgments, that could then be dealt with. It's oddly interesting that Alberta, Canada did part of the process back before 2015, but only recently this year fully enacted the actual more similar act there. But it has created, during the last 4 years, an understanding with Alberta, but also has left that opportunity available to all other countries and their foreign judgments, so long as they meet the criteria for comity. They can still do it that way. If they meet the criteria for the act, they can do it more simply. And I frankly don't have the information on other foreign countries. I don't know that it's even available as to how this act has actually impacted the investment of foreign country monies into the state of Arizona. But it is something that made it more feasible and palatable and more enticing to the foreign countries.
Anything else?
Only to state that I would ask the court to duly consider Judge Rogers' decision for a trial court to issue a 12-page decision that is so, I'll use the word wonderfully, written and easy to follow and adequately documented, that it makes for a good argument here in front of you today, and thank you for your time.
All right, thank you, Counsel.
Thank you. I'll be very quick with the 2 minutes I have remaining. Just quickly on the 12-page decision reference there, that was not the decision that deals with reciprocity. That was a commissioner's decision that is less than 6 lines long. Here's what the legislature thought of the common law. The Uniform Act includes a savings provision, Section 11, which preserves common law forms of recognition under comity. The legislature omitted that. It is not in the Arizona Act. That cannot be ignored. The Netherlands at each turn has tried to ignore that fact, coming up with the anti-abrogation doctrine and other arguments. The problem is our legislature has a savings provision in the sister state Judgment Act, 1702. That's a savings provision, and it's in the sister state Judgment Act. That's what counsel was referring to. That's not in the Arizona Act. So that tells us what they thought of the common law. And in fact, counsel refers to, we'll be the only state that does not recognize a Netherlands judgment. Well, you know, another thing we didn't enact in the Uniform Act, the uniformity provision. That is not in the Arizona Act. So the position of our legislature is we don't care what other states are doing. They pointed to, yes, Your Honor.
When we look at this act and why it was adopted, et cetera, it was to increase the accessibility of foreign judgments to be executed in Arizona. That seems to be the aim.
I would agree with that, except the language fast track. That's made up by the Netherlands.
I didn't say fast
Okay,
track. I
thank you.
said make it easier. So in making it easier, they give us a roadmap and they maybe, okay, we're not going to use common law because this is supposed to be easier. Would you agree with me that if we resort to common law, the judgment should be recognized in Arizona?
I disagree first with the premise that it'd be easier. Easier in the legislature's mind is you have a reciprocal law like Alberta, Canada does, a statute. But under the common law, no, I would not agree with that, Your Honor, because the Superior Court started from a false premise. It looked at the commissioner looked at reciprocity as, oh, these two court Dutch decisions are enough. Remember, the statute requires the Netherlands to carry the burden. So it's not enough to come here to this court or to say, let's explore other Netherlands decisions, let's pull those and see what they say. Why would the legislature put the burden on the Netherlands? That means you have to meet the burden in the trial court. And the commissioner just based her decision just on reference in a pleading to two Dutch court decisions. The decisions weren't in the record.
All right, thank you, counsel. Your time has expired. The matter is deemed submitted. We'll issue a decision in due course. The court's in recess.